Hello, my name is Charisse Lazara. I am the Child Support and Legal Referral Manager for the RWA program, and today we'll be discussing child support, rap sheets, and legal referrals. What is child support? Child support is financial support provided by the non-custodial parent. Child support includes cash payment based on the parent's income and needs of the child, health insurance for the child, payments for childcare, and payments for reasonable healthcare costs that are not covered by health insurance. Family court officials determine the amount of child support the non-custodial parent will pay. Under New York state law, parents are responsible for supporting their child until the child of 21 years old. These percentages are applied to almost all parental earnings up to 143,000 minus Medicare, federal insurance contribution, and New York City tax deduction. Child or spousal support actually paid based on a court order or written agreement may also be deducted before calculating the child support order. Earnings including workers' compensation, disability payment, unemployment insurance, Social Security pensions, and many other forms of income. After $143,000, the court can choose whether or not to use the percentage guidelines. In addition to the basic support order, the child support order must include medical support, which means health insurance and payments for any out-of-pocket medical expenses for the child. Either parent may be required to provide health insurance coverage for the child if it is available at a reasonable cost. The basic award may be increased to include a prorated share of childcare expenses if the custodial parent is working or in school. In addition, the court may increase the award to include a prorated share of educational expenses for the child. Also, when the court calculates support, it assumes that you can pay at least $25 per month even if you receive public assistance. Every state in the United States has a child support enforcement program, and many foreign countries have one also. The CSE program began in 1975 when Congress passed Title of the Social Security Act. Title 5D required every state to establish and maintain statewide child support enforcement laws, provide procedures to establish paternity, and to obtain court orders for child support, collect and distribute child support payments, and enforce the child support orders when payments are not made. In New York State, child support enforcement services are provided by child support enforcement units and support collection units in every county and in New York City. Any parent, guardian, or caretaker of a child who needs support can apply for child support services. Also, anyone who applies for temporary or safety net assistance automatically receives child support services. If seeking child support may result in physical or emotional harm to the custodial parent or the child, the custodial parent will be referred to a domestic violence liaison and may not be required to cooperate with the child support agency. Who can apply for child support services at the DOE Fund? Anyone who has an active child support regardless of the location and would like to have the support order modified to a lesser amount. Anyone who has an arrears case who is seeking to modify it. Enforcements due to child support arrears such as driver's license suspension, passport, professional licenses, and tax enforcements. What if you cannot afford to pay the full amount? Your child support obligation is ordered by the court. If you do not consistently pay your full child support obligation, you will build up arrears. To offset arrears, the amount you need to pay will be increased by 50% of your obligation amount. Depending on how much you owe, you could face a series of enforcement actions, such as driver's license suspension, tax enforcement, credit impact, passport denials, getting your license revoked, and professional license suspensions. If your income is at or below the self-support reserve, which is $16,389, or poverty for a single person, you should qualify for modification or adjustments. Can the amount required to pay change? You can ask the court to modify your current obligation amount based on a substantial change in circumstances, or if the order was effective on or after October 13 of 2010. It may be modified if any of the following: 3 years has passed since the order was entered or last modified or adjusted, either party's gross income has changed by 15% or more since the order was entered or last modified or adjusted, or you're incarcerated, or if the cost of living has increased by 10% or more since the order of support was made or last reviewed. Your current obligation amount will increase by the amount of increase in the cost of living. For example, if the cost of living increased by 15%, your current obligation amount will be increased by 15%. Employment changes. If you lose your job, you should do the following as soon as possible. Notify your local child support office. This step is required by law. Ask the court to review your order for support. Job loss does not end your child support obligation, and only a court can change your order. You are still responsible for paying the full court order amount. You may file a modification petition in the family court that issued your order. Arrange to make all or part of your support payments on your own. Participate in the garnishment program with the RWA program. Make good faith payments of minimum dollars of $25. This amount is garnished straight from your stipend, and it's garnished on the fourth Thursday of every month. This will allow you some time while addressing arrears and support modification. It can also help remove any enforcements or deter them from happening. This is the example of the trainee acknowledgement of child support garnishment that you will receive and you will sign if you wish to participate. Now we'll be discussing rap sheets. A record of arrest and prosecution sheet is a record of all your arrests and conviction. In New York, rap sheets are maintained by the Record Review Unit of the New York State Division of Criminal Justice Services. This here is an example of what a New York State rap sheet would look like. This is a federal rap sheet, which is issued for those that have been convicted of a crime outside of New York State. Why should you do this? You want your rap sheet so you know what others can see about you. Almost all rap sheets have mistakes on them, including incorrect information, information that should have been sealed, and missing court dispositions. This will give you time to correct any possible errors on your rap sheet before you apply for any jobs. 9 out of 10 rap sheets have mistakes on. This is not a typo. It is possible that you may not remember every conviction, so seeing a copy of your rap sheet beforehand will allow you to prepare for addressing your criminal history properly in interviews and on job applications, and you will be asked about it eventually in the interview process. Who can legally request your rap sheet? For one, you can. First and most importantly, you have a right to see your own rap sheet. Criminal justice and law enforcement agencies, such as police departments, courts, district and defense attorneys, parole and probation department, and the Department of Correction can also see your rap sheet. Certain employers are allowed to obtain copies of your rap sheet as part of the hiring process, including hospitals, nursing homes, home health agencies, banks, museums, schools, any employer who can legally fingerprint applications for hiring. Occupational licensing agencies. Examples of job requiring an occupational license include, but are not limited to, nurses, security guards, barbers, and taxi drivers. Here is a partial list of employers in New York State who are allowed to get your rap sheet from DCJS or the FBI. Why should you get your rap sheet? Well, for once, again, rap sheets have mistakes on them. Rap sheets are often incomplete and contain mistakes that can hurt your chances of getting a job or housing if they are seen by an employer or others. If you review your rap sheet before applying for a job, you can correct mistakes before they become a problem. For example, you might have been adjudicated a youthful offender when you were between the ages of 16 and 18. If entered properly in the rap sheet computer, YO information is confidential and will not be sent to an employer. Sometimes, however, the YO notation that would keep the case from being disclosed to potential employer does not appear on the rap sheet. Information that should be confidential is then sent to an employer who is authorized to see your record. If you notice a mistake ahead of time, you can make sure your YO records stay confidential. New laws to seal New York conviction. Criminal Procedure Law 160 subsection 59. New law that was passed in October, which states that New York sealing law allows people who have been convicted in no more than 2 cases, only one of which can be a felony case, to apply to seal certain convictions from New York if it has been at least 10 years since their sentencing or release from jail or prison. Only certain convictions are eligible for sealing, and there are other requirements as well, so please talk with us individually if you're trying to figure out your eligibility. Who is eligible to apply for sealing under the new law? You may be eligible if at least 10 years have passed since you were sentenced, not counting time served in jail or prison. You only have 1 or 2 criminal convictions in total. Only one of those convictions is a felony. Convictions for the following crimes are not eligible to be sealed: sex offenses, offense requiring registration of sex offenders, sexual performance by a child defined in the Penal Law, Article 263, a Class A felony, violent felony defined in the Penal Law, felony conspiracy to commit an ineligible offense, felony attempt to commit an ineligible offense. How do you apply? To apply for sealing under the new law, you must file a motion with the court where you were convicted. You must also serve a copy to the district attorney. The judge and district attorney will then make a decision based on your motion, or they can require a hearing to further inform their decision. Please make an appointment with me if you wish to apply. If you have a child support case and would like to address it or go over your rap sheet and create a conviction summary, or need referral for other legal services, please schedule an appointment by emailing me at the email shown or contacting me at 646-345-5928.